Donald Trump just slammed into what legal experts are calling the most devastating legal blow of his post-presidency. This wasn't just another courtroom setback. This was a public unraveling. The federal judge overseeing his criminal case didn't merely deny his request to halt the trial. She obliterated it. With precision, with authority, and with a level of clarity rarely seen in cases involving former presidents. And she didn't do it quietly. She issued a stunning 47-page takedown, not to clarify minor rules or parse technical jargon, but to expose what she described as a calculated effort to manipulate the justice system. Her ruling read less like a dry legal document and more like a line-by-line dismantling of Trump's entire legal strategy. She didn't hold back. She called his claims legally baseless, ethically troubling, and timed not out of necessity, but out of pure political gamesmanship. She even questioned whether Trump's own lawyers believed the arguments they were making. Judges rarely speak this bluntly, but this time, the message was unmistakable. The court is done playing Trump's games. That is a red flag from the bench. And in federal court, language like that does not disappear. It follows you. Trump's attorneys filed what they branded an emergency motion for mistrial, citing alleged misconduct by prosecutors, supposed tampering with jurors, and personal bias from the judge herself. They claim constitutional violations. They accuse the system of turning against their client. But what did they actually do? They submitted that motion at 11:47 p.m. on a Sunday, and they demanded a hearing before sunrise the next day. This was not legal urgency. It was courtroom chaos by design, a tactical stunt meant to force delay through confusion. But Judge Sarah Chen was not playing along. She saw through it, and she put it in writing. Here is what most people did not expect. Judge Sarah Chen was not only prepared, she was surgical. She did not simply deny the emergency motion, she dismantled it with the precision of a closing argument. Her ruling read less like a procedural denial and more like a point-by-point prosecution of Trump's entire legal playbook. She concluded in clear terms that the motion was not only meritless, it was weaponized. The misconduct claims were either invented or grossly distorted, and the real goal behind it all was delay and obstruction, a tactic aimed not at defending a client, but at stalling accountability. Now let that sink in. A federal judge put those conclusions in writing. She went on record accusing a former president's lawyers of misusing the court for political theater. That is not routine. That is a red line. And when a federal judge makes that kind of move in a written opinion that is now part of the public record, it signals something deeper. It says she is no longer tolerating what she views as deliberate abuse of process. It says the court has limits and Donald Trump may have just reached them. You do not see federal judges speak like this unless they believe the integrity of the entire system is at stake. To understand why Judge Chen went this far, we need to look at the trial itself. From day one, it has been a disaster for Trump. The prosecution has laid out overwhelming evidence, not in sound bites, but in binders, audio recordings, and devastating testimony from insiders. And how has Trump's legal team responded? With weak cross-examinations that often hurt more than helped, their objections have been overruled so consistently that it has become a pattern. This is not a courtroom where the defense is gaining ground. It is a legal battlefield where the facts are winning and Trump's lawyers are losing control of the narrative. Right from the opening bell, this case has looked less like a fair fight and more like a legal avalanche crashing down on Trump. The prosecution has not just presented their evidence, they have buried the courtroom in it, and Trump's defense has been reactionary and unfocused, constantly shifting strategies as if trying to dodge bullets in real time. But here is where things turned. As reported on December 6 by Politico, Trump's lawyers made their move late. Not just metaphorically, but literally. They filed their emergency motion at 11:47 p.m. on a Sunday. Think about that. 11:47, that is not strategy. That is ambush litigation designed to force the court to scramble or slip. This was not a casual filing. It was a 183-page document stuffed with exhibits and explosive claims. The defense alleged, among other things, that prosecutors had improperly prepped witnesses, that jurors had been tainted by biased media coverage, and that Judge Sarah Chen herself was so partial and so compromised that a fair trial was impossible. But they did not stop there. They demanded that Judge Chen recuse herself. They asked for a mistrial. They even hinted that the entire indictment should be thrown out. That was not just aggressive, it was a full court press against the judicial system itself. The message behind that filing was unmistakable. This courtroom is the enemy. What we are seeing is not a traditional legal defense. It is a political strategy dressed up in court filings. Trump's team is no longer trying to win the case by contesting the evidence. They are trying to blow up the process, delay the outcome, muck up the system just long enough to create chaos, and maybe give themselves something to appeal. Legal scholars speaking to CNN called the allegations in that emergency filing extraordinary. And they were right. If even one of those claims were true, if jurors were truly tainted, or if a judge were truly biased, it would demand immediate intervention. But what if none of it was real? What happens when emergency becomes just another word for disruption? Here is the blunt truth. None of the claims in Trump's emergency motion held up. Not one. And it is worth remembering what these emergency motions are actually for. In the American legal system, they are meant for real urgent threats. Moments where waiting even a day could cause irreversible harm. They are not meant to be legal smoke bombs tossed in when you are losing a case. When you misuse that kind of legal tool, you are not just playing dirty. You are undermining the very system your client depends on to stay free. That is not advocacy. That is sabotage in a suit. So what happened next? Judge Chen did not blink. She scheduled a hearing for 8 a.m. Monday morning, giving the prosecution only a few hours to respond. No delays, no extensions. According to courtroom journalists from CBS News, the room was packed and tense when the session opened. Trump showed up looking calm, maybe even confident, likely expecting that his motion would at least jam up the courtroom and buy time. But ask yourself this. When you walk into federal court assuming your political stature can bend the system, what happens when it cannot? The government responded first, and they did not simply rebut the claims, they dismantled them point by point. The prosecutor explained that what Trump's lawyers called witness coaching was standard legal trial preparation, something every defense team does. As for the jury bias accusation, the prosecutor reminded the court that jurors are questioned every day under oath about outside influences, and not one had reported seeing the news stories Trump's team suddenly claimed had tainted the trial. These were not real issues. They were manufactured landmines, and Judge Chen was not about to step on them. The prosecutor did not skip over the most volatile claim, the suggestion that Judge Chen herself was biased. She addressed it directly, walking the court through example after example, where rulings that Trump's team labeled unfair were in fact legally grounded and thoroughly justified. But then came the bombshell, not from the bench, but from the evidence. The government revealed that Trump's own legal team had leaked information to reporters in the lead-up to the very media stories they now claimed had poisoned the jury. Think about that. They triggered the press coverage, then ran into court shouting prejudice. That is not a legal defense. That is a setup, a political trap disguised as a procedural complaint. Phone records showed one of Trump's attorneys had spoken with journalists from 2 major networks just hours before the stories went live. And those were the same articles the defense tried to cite as grounds for a mistrial. It is a circular fire. You spark it, then you cry foul when it burns. And in a courtroom, that is not only hypocrisy, it is strategic deceit. It is also incredibly risky because once the court sees that you created the crisis, you are now demanding relief from your credibility collapses. It is not just about losing a motion. It is about losing the trust of the judge, and that is a debt you rarely recover from. Judge Chen responded with what courtroom reporters have described as one of the most stinging judicial reprimands in recent memory. She did not soften her tone. She labeled the motion an outright abuse of legal procedure. She said the factual claims ranged from completely baseless to outright distortions. And when it came to the personal attacks leveled against her, she went further, making it clear that accusing a judge of bias without meaningful evidence is not just reckless. It is a line-crossing offense that can result in real disciplinary action. This was not just a ruling. It was a warning shot aimed squarely at the ethics of Trump's legal team. The moment Judge Chen delivered that reprimand, the room froze. It was not only her words, it was the clarity, the authority, and the public nature of it. Judges rarely speak this bluntly about attorney conduct in open court. When they do, it signals more than frustration. It signals a breach of courtroom ethics. And in this case, it was a full indictment of Trump's legal approach. Her tone made one thing clear. She is done tolerating tactics that weaponize the legal process. But this tactic, filing emergency motions as legal grenades, is not new for Trump. It is part of a long pattern stretching back through multiple high-stakes courtrooms. We have seen this script before. When the evidence begins to corner him, Trump's team does not double down on the facts. They start attacking the process in the New York civil fraud trial. As damning testimony piled up, his lawyers shifted from defense to delay. Emergency motions, bias claims, appeals designed not to win, but to stall. This was not legal strategy, it was procedural warfare. The goal was not a fair trial, it was a frozen one. And each time the courts pushed back, the response was not reflection, it was escalation. They claimed he was being politically targeted. They argued the judge was against him from day one. They insisted the trial should be tossed before it even ended. But the courts were not buying it. Those accusations were reviewed and rejected one after another. The case moved forward, and in the end, Trump was hit with a penalty of more than $450 million. That is not noise. That is consequence. And this was not an isolated incident. The same obstructionist pattern showed up in the Ian Carroll case as well. His lawyers attempted delay after delay, arguing procedure while ignoring substance. And again, the court saw right through it. At one point, Trump blatantly ignored a court order by continuing to post inflammatory remarks about the trial on social media while the trial was still underway. That recklessness did not just violate decorum, it triggered financial penalties and further eroded his legal standing. And it was not a one-off. In the classified documents case, before it was dropped on a procedural technicality, Trump's team flooded the court with motion after motion. Some were repetitive, others bordered on absurd. Judges flagged them as meritless and a waste of the court's time. The pattern was obvious: file, stall, repeat. Not to defend, but to delay. This is not about defending innocence, it is about draining time. In the January 6th prosecution, Trump's lawyers tried to bypass the trial altogether, racing appeals up to the Supreme Court. They lean heavily on the idea of absolute presidential immunity, as if holding office somehow places you above the law. But there is no constitutional basis for that claim. Legal scholars across the spectrum said so. The courts have said so, and yet the tactic persists. Why? Because in Trump's world, sometimes delay is the defense. Not the facts, not the law, just the clock. Judge Chen, however, appears done with the clock games. Her written opinion was not just a rejection, it was a statement of intent. She signaled in clear judicial terms that future delay tactics would be met not with tolerance, but with consequences, and not only procedural ones. Sanctions, court discipline. She is drawing a line, and the question now is whether other judges will follow her lead. Because what she laid out in that opinion is not only about this motion, it is about Trump's entire legal playbook being placed on trial right alongside him. Judge Chen did not just deny the motion, she used it to build a comprehensive legal roadmap that could follow Trump through appeals and possibly damage the professional standing of his lawyers. According to CNN, which reviewed the full ruling, 30 of the 47 pages were dedicated solely to dissecting each accusation raised by Trump's team. That is not only legal rebuttal, that is systematic dismantling. Regarding the claim of witness manipulation, Chen reminded the court that prosecutors have not only the right, but the ethical duty to prepare their witnesses before trial. That is courtroom 101, and pretending it is misconduct is either careless or cynical. Then came a sharp pivot. She pointed out that Trump's own legal team had done the exact same type of preparation, undercutting their entire argument. That is not only hypocrisy, it is a strategic contradiction that collapses under scrutiny. On the question of jury contamination, Chen explained that jurors are questioned every single day about outside influence. Not one had reported being exposed to the specific media coverage the defense suddenly claimed was contaminating the trial. So ask yourself this: if no juror saw the coverage, was this motion ever about fairness? Or was it simply a public relations stunt designed to create a headline? And then she delivered what legal analysts are now calling the core of her opinion: proof that Trump's own team planted the very media narratives they later used to cry foul. Let that land for a moment. The defense triggered the coverage, then tried to weaponize it. But Chen did not stop there. On the issue of alleged bias, she came armed with facts. She detailed multiple instances where she ruled in Trump's favor, from objections to motions. So if this judge were truly out to get him, and why was she granting him procedural wins on the record? The contradiction speaks for itself. Judge Chen did not stop at defending her impartiality. She laid out the actual courtroom accommodations she had extended to Trump's team: extensions for filing deadlines, additional preparation time, schedule flexibility, and then one by one, she walked through the defense's accusations of bias, explaining the legal rationale behind each decision. What she showed, and what any trained lawyer should have recognized, is that those rulings were not biased. They were consistent with federal law and courtroom precedent. In fact, her transparency placed the burden back on the attorneys if they misunderstood those rulings. Was it incompetence or intentional misrepresentation? Then came the part of the opinion that packed the largest political and legal punch. Judge Chen wrote that the emergency motion was not about substance at all. It was structured to delay the case and generate headlines, not justice. She noted the Sunday night timing, the 183-page filing, and the Monday morning demand. All of it, in her words, pointed to a motive rooted in chaos. This was not legal urgency. It was narrative engineering designed for public consumption, not courtroom resolution. And in doing so, it exploited the very system it claimed to defend. Her written opinion went even further, warning that tactics like these, quote, bring disrepute to the legal profession and erode public trust in the judiciary. That is, in legal terms, a nuclear rebuke. According to legal analysts at MSNBC, when a federal judge uses language like that, it is as close as the bench gets to accusing attorneys of deliberate dishonesty without saying it outright. But make no mistake, that language carries consequences. It enters the record, it raises the possibility of disciplinary review, and it places every lawyer who signed that motion on a collision course with their own state bar. Yes, defense attorneys have a duty to defend their client vigorously, but they also have ethical duties to the court, to the public, and to the system they practice in. Judge Chen made it clear that those boundaries were not respected. Her written opinion strongly suggests that Trump's legal team crossed a line from zealous advocacy into procedural abuse. According to a retired federal judge speaking to CBS News, written rebukes this strong and this unfiltered are almost never seen unless the court believes that the integrity of the process is actively under attack. And in this case, that is exactly what is on the table. What this ruling revealed, and what no spin can undo, is that Trump's legal maneuver was not rooted in fact or law. There was no emergency. The claims lack substance. The motion was built not for justice, but for optics. Legal theater at its most cynical, and the record now reflects that in black and white for every appellate court to see. But instead of showing restraint, Trump did what he often does. He escalated. He logged on to Truth Social and went on the offensive. He did not just criticize Judge Chen. He smeared her, calling her a partisan, attacking her integrity, and even suggesting she should be investigated. Then came the contradiction, one so glaring that even some of his allies could not defend it. Trump claimed the opinion was proof the judge was biased, that no fair judge could possibly issue such a strong critique. But here is the problem with that logic. The critique was not political. It was legal, rooted in rules, evidence, and courtroom behavior. And when legal experts pointed that out, Trump's team fell silent. The silence said everything. You cannot accuse a judge of bias for enforcing the law and then prove her point by launching personal attacks when she does exactly that. That is not strategy. That is self-sabotage. That public meltdown on social media did not go unnoticed. It pushed the courtroom from legal procedure into a new realm entirely. Judge Chen issued a formal order demanding that Trump explain why he should not be held in contempt. Why? Because directly attacking a sitting judge during an active trial walks dangerously close to obstruction. It is not just disrespect, it is interference. And what makes this moment different is that it is not Trump's first time. It is a pattern, and this time the court is signaling that pattern equals liability. The judge did not stop at a warning. She scheduled a contempt hearing, placing Trump at immediate legal risk. The possible penalties include monetary sanctions, yes, but also jail time, even if brief. Now here's the political tightrope. Trump thrives on conflict. He leans into defiance. His base rewards him for it. But in this case, every defiant post and every swipe at Judge Chen deepens the legal jeopardy. It strengthens the court's argument that his actions are not protected speech, but calculated defiance meant to disrupt justice. So the strategy that wins him applause outside the courtroom may get him sanctioned inside it. And let's not ignore the people sitting silently in the jury box. Jurors see everything. If they watch the defendant lash out at the judge, it is not hard to imagine the impact. They might read it as arrogance, as hostility toward the very system that is deciding guilt or innocence. In a close case, that perception matters. But what is most remarkable is that Trump does not or cannot stop. Even when the consequences are visible, even when restraint would help him legally, it is as if political impulse overrides legal logic. And that may be one of the most self-destructive instincts in this trial. Donald Trump is now facing a dilemma of his own making, one with no clean exit. He can double down on attacking Judge Chen, embracing the fight, feeding the headlines, and risking full-blown contempt charges. That path leads exactly where you expect it to lead. Sanctions, possible jail time, and potentially being barred from his own courtroom. It would be explosive. It would dominate the news cycle, but it would also strip him of the chance to defend himself in front of the jury that still holds the power to decide his fate. Or he could take the harder path. He could back off. He could stop the attacks, follow the judge's orders, and comply with court protocol. But that would mean breaking character, pulling back in public. And to Trump, that kind of compliance does not feel like legal prudence. It feels like weakness. His political persona is built on combat, not concession. But here's the catch. It is the only route that keeps him out of a holding cell. And even that may not be enough to undo the damage he has already triggered. Behind the scenes, this is not just a legal mess. It is a full-blown campaign crisis. His advisors are reportedly scrambling. The idea of their candidate being jailed mid-trial, not for the charges themselves, but for courtroom behavior, is terrifying from a strategic standpoint. The base might rally, but independent voters, swing states, those voters want stability, not spectacle. What looks like defiance to the loyalists looks like a meltdown to the middle. And when the person asking for your vote cannot even follow a court order, the campaign is not simply off message. It is off the rails. Now we are seeing the ripple effects hit the Republican establishment. Lawmakers who have spent years defending Trump, often at the expense of logic or principle, are suddenly silent. When asked by Politico whether Trump should stop attacking the judge, several GOP senators offered no comment, no defense, no spin, only silence. And in Washington, silence is not neutrality, it is a signal, a quiet admission that this time the conduct crosses a line even they cannot publicly justify. Because defending a man who attacks the rule of law while on trial is not just risky, it is radioactive. Legal experts, and not only from one party, are sounding alarms. Even attorneys who have historically supported Trump's legal rights are distancing themselves. Why? Because lashing out at a presiding judge during an ongoing trial does not read as strategy. It reads as sabotage. One former federal prosecutor called it the definition of self-inflicted damage. And then the conversation escalated further. The American Bar Association, which rarely weighs in mid-trial, released a pointed statement about preserving judicial independence. They did not name names, but they did not have to. The timing said everything. Let's be clear. The statement was a warning not only to Trump, but to anyone watching who might confuse defiance with leadership. It reminded all litigants, including those facing criminal charges, that respecting the court is not optional. It is foundational. Legal analysts now believe Judge Chen's ruling will have implications far beyond this case, not only because of the content, but because of the precedent it sets. When a judge draws a line this forcefully and backs it with legal clarity, it becomes a roadmap for others. And Trump's behavior is being written into the legal record as a cautionary tale. Andrew Weissman, one of the most experienced federal prosecutors in the country, went on national television and delivered a warning that cut through the noise. He said Judge Chen's opinion was not just a ruling, it was a blueprint, a judicial playbook for how to shut down Trump's go-to legal tactic, delay by disruption. The opinion meticulously mapped out the behavior, not only in this case, but as a broader pattern. And that is where it becomes critical. When a judge places that kind of documentation into the public record, she is not just handling one defendant. She is building legal architecture for the courts to use again. That is the part Trump's legal team should fear most. This is not a one-off embarrassment. It is now usable precedent. The next time he or his lawyers try to pull the same stunts in another court, a judge will not have to start from scratch. They can cite Judge Chen's opinion and move directly to denial. No debate, no delay. Neil Katyal, former acting Solicitor General, added that the ruling could have serious consequences on appeal. Why? Because appellate courts overwhelmingly defer to trial judges, especially when that trial judge took the time to thoroughly document misconduct and abusive process. So let's put it all together. This was not just a denial of one motion. It was a strategic strike, a preemptive wall against the entire strategy Trump has used in court after court. And now that wall has legal footnotes. With this ruling, his toolbox of procedural tricks just got much smaller. And if you are wondering what is really at stake, it is more than this case. This ruling could shape how Trump is treated in future trials, how appeals courts view his conduct, and how much longer delay can protect him from the law finally catching up. Let's start with what this means for the trial at hand. The emergency motion was shut down flat. No compromise, no reconsideration. That means the trial stays on schedule. No delay granted. But even more important is how Judge Chen framed her ruling. She made it unmistakably clear that any future stalling attempts will not be tolerated. They will be punished. That is not a warning. That is a legal line in the sand. And now with contempt proceedings already in motion, Trump is not just battling charges, he is facing personal accountability for the way he has attacked the process itself. And here is the kicker. If Trump is found in contempt, it immediately hijacks the spotlight. Whatever defense strategy his lawyers had is drowned out by the narrative of a defendant punished during his own trial. If he is jailed even for a day, it shifts the entire courtroom dynamic. The jury sees the empty chair. They ask why. And whether it is explained or not, it speaks volumes. Jurors do not forget a defendant missing from trial. They do not ignore courtroom conflict. In a case where perception matters, this could become more damaging than the evidence itself. And the ripple effects go far beyond this courtroom. Judge Chen's opinion now sits on the public record, fully cited and fully sourced. Prosecutors across the country now have a judicial framework to reference when Trump's legal team tries this playbook again, and judges will be empowered to act faster. Once a fellow federal judge has established a pattern of bad faith, others gain precedent to shut it down. This is not only about stopping delay, it is about creating a systemic response to a tactic that has undermined courtroom credibility for years. And now it may finally have hit a wall. Trump's long-practiced tactic of legal delay. The stall until it fades approach has now hit a legal wall. With Judge Chen's opinion now part of the federal record, other judges do not need to reinvent the wheel. They can cite her detailed findings to immediately deny similar motions. This is not theoretical. It is structural change, and it places Trump in unfamiliar territory where time no longer protects him. What does that mean politically? It means Trump may soon face contempt charges, not from pundits or partisans, but from the federal bench, all while campaigning to return to the presidency. Now picture this, a presidential candidate on criminal trial, possibly sanctioned or even briefly jailed for contempt. That image does not simply complicate campaign optics, it rewrites them. Swing voters tend to reward order, not chaos, and Republican candidates now find themselves cornered with a choice. Either defend a man formally accused by a federal judge of abusing the legal process or break ranks. And for Democrats, they are handed more than rhetoric. They now have a 47-page federal opinion laying out in sharp legal prose that Trump's defense strategy was not just flawed, it was dishonest. Here's the bottom line. Trump's legal team filed a motion they called urgent, one that Judge Chen methodically tore apart. She found it frivolous, factually inaccurate, and motivated not by law, but by disruption. And when that did not work, Trump did not course correct. He lashed out on social media, against the judge, against the court. That move, more than the motion itself, may cost him most. Because now, instead of dictating courtroom momentum, he is fighting off contempt. This was not just a tactical misstep. It may be the moment his strategy collapsed under its own weight in full public view. This is not only the story of one legal loss. It is the moment an entire strategy built on disruption, delay, and distortion was pulled into the light. Judge Chen did not simply deny a motion. She exposed a pattern, and she did it in writing for the world and the record to see. If Trump ends up sanctioned, fined, or even briefly jailed for contempt, it would mark the first time the legal system imposed meaningful consequences for behavior he has repeated in courtroom after courtroom. For years, Trump's legal tactics have danced at the edge of ethics. Now it looks like the system is finally pushing back. That pushback is bigger than this trial. It signals a turning point where legal norms reassert themselves against political power plays. Trump has long relied on the idea that if he is loud enough, aggressive enough, he can shape reality, even inside a courtroom. But the courts do not bend to branding. They answer to law. And what Judge Chen's ruling makes clear is this: there is a limit. There is a point where even a former president cannot spin his way out. And when that line is crossed, the question is not only about Trump. It is about the health of the rule of law in America. The contempt hearing is coming. The trial moves forward. And Judge Chen has now set a precedent in her courtroom. Trump's familiar tricks do not buy him time here. The stakes are massive. The fallout is not theoretical. The entire country is watching a courtroom test not just a case, but accountability itself. We are no longer in the realm of hypotheticals. The next chapter could bring real penalties, real consequences, and a real reckoning. Whether the legal system holds or folds is about to be tested in front of cameras, voters, and